A very good evening to all the participants and a special good evening to today's resource person, Dr. Deevanshu Shrivastava.
I'm now opening the floor or the room for the discussions or questions. So, whether common law remedies are available for the infringement of trademark and the protection of cybersquatting? Yes, sir. Till now, I'll tell you the major remedies that we see are under the perspective of the common laws. Also, to understand it with more of an Indian perspective, the remedies which is provided under the Trademarks Act are still or can still be used under the cyber world as well. So whether it the best part for us or as a student, if I was asked this question, so don't you feel that there should be a separate legislation be brought, um, that in spite of bringing IT Act and Trademark Act and IPC together, can we have a separate act for the same? And my answer would again be a no, because um, it's always good to get three set of laws giving a wider ambit. And if again, if I have always cited this, one of my very favorite subjects, I would say, is Contract Act. And the rule of communication, I guess we all my law friends who are here, the communication rule that we refer to 4, 5 and 6, the revocation, the communication when it gets complete and other things, we all have agreed to a point that whether it is an e-commerce website or now whether we are contracting through emails, the rule of section 4, 5 and 6 under the Contract Act is not changing. In the similar way, whether it is an infringement in a real world or if it is an infringement of a trademark in a virtual world, the rules and the basics of the trademark is not going to change. So I hope that would justify that. Satyendra, he has another question. Sir, I have a question. Hypothetically thinking, a company registered its name as smartsolutions.com, provides for internet-based resolutions for smartphones and computers, and is functioning appropriately. Another company, smarttechnology.com, that manufactures some gadgets and softwares, launched its new software, Smart Solutions, which was being developed from a longer period and reflects to the name of the existing company. This company asks prior to transfer the name for the misconduct. How can such be? Okay, so then I guess the answer to your question is itself mentioned in the second last line, where you say that it reflects to the name of the existing company. So now, when if you are putting me in the or I'll say let us you Satyendra, me, and I'll also request one member from DPIIT IPR-Chair, let's say Irfan sir. So we three are the bench here. Now, before we dive into the Trademark Act, before we dive into certain things, the first and the foremost question, and I would also take help that how the common law perspective was on the same. My first question to the person would be why, and because existing company is already there, Smart Solutions, why are you naming your product as the similar thing which is there? Number one, you got this idea because of the dominance or because of the capital, because of the market that the Capital Solutions have already had. And if they come out with a reason, because again, it's an hypothetical thing that we can only assume for those particular facts, the reason should be there. And if they come out, for example, with a very logical reason that this is the reason and we have been doing this particular fact, I'll still go by that how this would be violative to the original ones with the smartsolutions.com. So this is one thing that is being taken across. We have next question by Nandini CP. Are they typo squatting, sir? Yeah, the misspelling is generally, again, it's a word where cyber squatting is taken with the typo squatting as well. The form of the words being used in the different countries, different thing, but the major crux remains the same, whether it's a typo squatting or it is something in relation to your changes that we see, everything is there. The prior company had no idea about the second company developing such a product in such name. What is the jurisdiction of such a dispute? What solution can be provided to such disputes? Okay, the private company had no idea, they had to be proved again. So that comes with the, I guess, again, an IP enthusiast, the honest and concurrent user. So remember, it's not only that you are taking one particular perspective and taking. I can give you a number of examples where the similar name has been used for different products. You can search it for 555. So this was considered to be a very important number, but at present, if you see, there are, to the best of my knowledge, there are 3 products being delivered or being there or being floating in the market with the name of 555 and by 3 different distinct people. So the point which I'm trying to tell out here, that if it's an honest and concurrent usage and it is not bifurcating or not interfering in the market of the other, I guess the problem can be solved by granting them both. Is it possible to create the same domain name for 2 firms? I guess, Kishore, I was moving to your question, but yes, this is again what we were discussing. If it is not in the domain of the other, and it is, again, I'll tell you, whether it's IPR, whether it's anything, why a dispute happens? When one person asserts and the other denies, then only a dispute arises. And if that dispute is under a trademark, this is termed as a trademark dispute. But if one person is asserting and the other person is accepting, there would be no dispute ever. And you can put this formula anywhere: movable property, immovable property, tangible properties, intangible properties. You will, that's the best answer for how to identify whether there is a dispute or not. So please tell us the progress, considering that there are cyber issues and statutory provisions which apply here, such as IT Act 2000. Can you cite cyber squatting remedies via IPC or IT Act and the trademarks conjoint relating could be sufficient to address the issues? What are the jurisdiction issues server hosted across countries which may there, and how it can be resolved by CPC as a procedural law? Okay, so Samrat, there are provisions, and that would always depend upon how and which type of cases are there. So again, which sections of Trademark Act would be there? So there is an entire chapter under the Trademarks Act that talks about the offenses and penalties, read with which type of offense has been taken. Same thing is with the IPC getting attracted. IPC generally, when the trademark owner, okay, so the remedies which we see under the trademarks are of two nature: civil remedies and criminal remedies, depending upon the trademark owner to take whichever, only one can be brought. So that is something depending upon the case and which type of domain name, in the case of cyber squatting, in case of also the remedies are also provided in the same way as what can be claimed in the prayer clause. So there are accounts of profit as well. Whatever the profit has been done has to be shown and has to be delivered. So those things can also be taken. Can you cite how to substantiate the evidence in such issues of cyber squatting? Again, look, do not deviate from the traditional concepts of the evidences. Now, under the Evidence Act, burden of proof was one thing which I tried to tell you. Now, in case of a cyber squatting dispute that happens between A and B, let's say A was the owner of the trademark who filed an application for the cyber squatting dispute, and B is the one who is basically alleged for being involved in a cyber squatting case. The proof from A side would be the 3 basic documents that would be required at first go. The first and the foremost, that the thing for which he's claiming that particular thing is his own trademark. That's where the BOP, the burden of proof question, comes into play. The plaintiff needs to prove it that this is 2 things. This is my domain, this is my trademark, and the X person, or in our case, B, has violated the trademark by this way. Once this is established, then only the case went ahead. Else it would be dismissed at that particular point. So for example, if A was the person who was the owner of the trademark, he is unable to prove that that name or that thing was his trademark, the case would not proceed ahead. Or if he fails to prove that there is an infringement, the court is not able to accept the fact that there has been infringement, then in that case as well, the case would not move ahead. So what would be the evidences? In that particular case is the registration certificate, the usage thing, if for example, if it was a family business, what all things have been there. Like generally we see the on the shop, it is established in the year 1988, since 25 years in your service. So these are certain proof which the court is accepting, okay, this trademark belongs to this particular person. Or A's father was using that particular business. He established that business. He died. The business then transferred to his son A. And this is how those particular things are being carried out. Then when it is alleged that B has done an infringement or a cyber squatting in this particular case, what all things would be taken, how those particular things would be bringing this particular point to be an infringement. Now, there can be two conditions. Number one, B proves it that this is not an infringement, but it is something from the perspective, or it can lie under the defenses which is provided under the Trademarks Act. One among them was the honest and the concurrent usage. The other, that it was an unintentional thing, but I am ready. And there can also be a point that I was unaware. Now, when I'm aware of it, I understand, therefore, I'm not going to use it, where he himself accepts the fact. So there are all set of things, and this similar thing, the Trademark Act, or for example, how those particular points would be into consideration when it comes to cyber thefts, the domain name thefts, or the sections like 419, 420 of IPC, the personification, the cheating, those things are also being brought. Also, the frauds that are being taken into, the deceits, that is where also the IT Act would take into. What would be the effective remedy to settle domain name disputes in India and at the international level? Any reform can be brought to settle domain name disputes. I would totally agree, Jagdish ji, on this. I referred to that in the last 3 slides as well, that we have the UDRP for an international forum, and it's working very, very, very efficiently. Similar line things, I'm not saying that the Indian courts are not effectively working on domain name disputes. They are. They are using the common law method. They are also using the existing laws out here, clubbing it with the IT and the trademarks together. But yes, if you bring across the UDRP or something in line to the UDRP, that will be much more effective when it comes particularly to the domain name disputes. So that can be taken. I'll suggest particularly to Jagdish ji, and through him to everybody, again that urge, please read the UDRP. I guess the answer lies in out there. And I am always of a believer, and something that my teachers in IPR have taught me, that the best way to understand an IPR concept or something that we need to take is to teach fishing rather than to give a fish in the plate. And this is where I'm urging each one of you who are interested of this dispute resolution thing, read the UDRP once. And you can automatically, believe me, take a pencil in your hand. You can automatically write, okay, this is a jurisdictional issue that I can put for CPC. This is something that we can put in the Trademarks Act. It is all settled out there. So that can be very, very, yes, INRDP, again, I can come to that particular point. The registry office is using it, but the problem with IRP is only one, that still it has not been recognized. And the concept of, again, the dispute or the major dilemma for the courts, whether to go with the legislations or with the policy, is a major thing that comes into it. The purpose why I was not mentioning INDRP, and now when it is being brought, INDRP, if you read, has couple of problems. It is number one made on the line of the UDRP, but there are couple of issues that have been there. If you can, I'll appreciate Jagdish ji if he has brought this point. Do also search what are the critical analysis of INDRP, and you'll identify the answers, which are some of the basic points which has to be taken into consideration. A company have a multiple domains. Example, Amazon company has Amazon.com, Amazon.India, .uk, and many more. Do all these domain become trademark of the company using it to acquire multiple trademarks? Second, look, again, your question itself has an answer. Amazon.com Amazon.us, Amazon.uk, Amazon.in. We all know that the IPRs are country specific. Amazon.us cannot claim its trademark in India. In the similar perspective, for that particular brand, and this is not only for Amazon, you can see PepsiCo. So PepsiCo is a company, that is the Pepsi company. And when it comes to the India, the website reads as pepsico.in. It goes to Australia, it's pepsico.au. It goes to Pakistan, it is pepsico.pk. So, and also one thing, you see, I am a bit sports enthusiast as well. So official sponsors for the Pakistan cricket team is Pepsi right now. It is not the PepsiCo.in. It is the PepsiCo.pk, which is the official sponsors of the Pakistan cricket team. Now, the point which I'm trying to tell you, that they all are referring, and the reason why they come across with this country level domain CCTLD is that they can claim the trademark in the country. Now, for example, they entered into a new country called as Somalia. Amazon.Somalia. I am unable to identify the CCTLD that would be used for Somalia. But before they entered in 2022. Let's take an hypothetical situation. If they entered in 2022 and already somebody was using that particular name in Somalia, who would win in that trade name dispute? The answer is always and always depending on the factual conditions. What services? Why for Amazon? Because Amazon, again, we all know Amazon draws its name from the Amazonia forest. And that is how this particular, and they were firstly into the books, the card books and other things, and then they expanded their companies. Any relationship between copyright law and the cyber squatting, sir? Again, there are issues, but number one, the topic for today is majorly focusing trademark. One thing for a copyright thing for that comes, it can never be on the domain names. Squatting cannot cover the particular domain name. But yes, when it comes to the other perspective, because you do not claim a copyright over the domain name. So this is one thing that we need to keep in this, keep this in our thing. Also, the domains within the IPR, something that can be patented cannot be copyrighted or trademarked, and in this same way across. So Sarin has a counter question to that. So if such domains are already acquired by individual to sell them back to the companies, no, it is not. And that is where Amazon would file a case that would say that what is the reason why that particular person was claiming Amazon. Like I and you cannot claim Amazon. For what reason? Because we know and we are trying to use it. But if for any such hypothetical reasons, again, I am able to establish this thing to the court that why I was using Amazon. Okay. I have established it. I've used the defense of honest and concurrent use, and I've established, and the court is agreeing to me. Then they can offer me to buy this particular domain name from me, which is a legit one. So in also the previous question that you asked, Facebook.com has bought that FB. Now FB can be for fringe benefits as well. FB can be for fire brigade as well, which is a completely distinct domain. But in that particular case, can I offer that particular? Again, that is no matter of dispute. That is no matter of dispute. The court can only say it when it comes to the dispute table, when it comes to the courtroom. Outside the court, if the person, like for example, I was using Amazon, I am ready to sell it to Amazon for $10 million. It is between the parties. It is between the guided personam, and that is what it is being covered. So thank you so much, everybody.
Thank you, sir, for your for patiently answering all the queries, and also for the detailed analysis that you have provided with respect to internet domain names and its relationship with trademark. Sir, as you have rightly pointed out, there is no specific law that is dealing with domain names and trademark, and the Trademark Act itself is providing the remedies.
Thank you very much, Dr. Deevanshu, and it was really a wonderful session. Your lecture has been really enlightening on an emerging area. And I think a lot of work needs to be done in India. No doubt, we have certain judicial developments, but at the same time, I think domain names are going to play a vital role in the coming years in the digital era, and the interface with the other intellectual property rights, and certainly the emerging areas, whether it is artificial intelligence or non-fungible tokens, or similar forms, they will hold relevance for these areas. Thank you very much for enlightening our participants, and we hope to see you in our platform, on our platform once again very soon. And I'm very happy that young academicians are doing exceedingly well, and that is evident today. Thank you so much.